Okay, so as I said, I'm from an organisation called the British Institute of Human Rights. And I'll tell you a bit about us in a moment. But before I do that, I just wanted to start with some people. Because fundamentally, at their heart, human rights are about human beings. And too often we kind of see the law as something that's kind of particularly complex or is kind of too difficult maybe to manage or isn't necessarily relevant. But actually our human rights law is all about regulating the power that kind of officials and public officials have over people, and they're particularly important when people are facing kind of vulnerable moments in their lives. And these are just some of the people who we have worked with through our advocacy projects and partners, for whom the Human Rights Act has made a real difference. But I actually just wanted to start with a story which is slightly personal and also one that you won't find written down in any of our materials. And that's because the family involved didn't want it shared in that way, but they're happy for us to talk about it. And it involved someone who we'll call VJ, who was an older man. And he was living in a care home, and sometimes he got into respiratory problems, and his breathing kind of got quite laboured, and it got quite difficult. And essentially there was a particular type of respiration that he needed, and then kind of he was able to get through that situation. And on this one occasion, his daughter phoned up the advocacy service that we were working with the manager on a Friday night and said, "Oh, I don't know what to do. My dad, his breathing is really bad, but the on-call doctor at the care home, who hasn't seen my dad, has said that they're not going to give him treatment and that maybe it's just my dad's time." And the manager said to her, "Right, well, first of all, ask the doctor if he's thought about your dad's right to life and then get a second opinion." And she didn't need to get a second opinion. She just mentioned my father's right to life, it's protected under the Human Rights Act, and that decision was instantly changed. Her dad was put on the respiration treatment that he needed, and he's alive today, and he wouldn't have been. And the reason that's a particularly personal story is because that's how one of my grandfathers passed away, and I didn't know anything about the law. And had someone known something about the law, maybe that outcome would have been different as well. And too often we forget the human at the heart of human rights. But that is precisely what my organisation is all about, the British Institute of Human Rights. We sound like a very grand, kind of maybe quasi-governmental organisation, possibly an academic one, pontificating about human rights law somewhere in an ivory tower. That is not the case. At the moment we are on a community outreach tour, and this is day number 14 of 15 days of straight solid action. So I'm very grateful for the microphone because my voice is starting to fail me now after delivering about maybe 20 events in the last 14 days. And what BIHR is, as a charity kind of which is independent, as all charities are, but we're committed to bringing human rights to life across the UK. So breaking all the rules, what I'm going to tell you about is what we don't do. We don't do court work, we don't do litigation, and we don't do legal advice. And the reason we don't do that is because that's the last resort. Because actually, if we all knew a bit more about our human rights, if we all knew how to hold those with duties to account in our everyday advocacy and negotiation, then the need to go to court is very much reduced. And that's what my organisation is all about. So we empower people to know what human rights are, often what they're not as well. There's a lot of misinformation and confusion out there about it. We do that through education, through information, through practical resources. I'm just going to nip down for a moment. Because hopefully in your bags you should have one of our resources, which is our community, our Human Rights for Community groups, which is one of our kind of general advocacy resources. Our resources are co-produced with people themselves, and we have resources that are specifically around advocacy and around issues to do with things like mental health, for example. And that's because uniquely amongst human rights organisations, we don't just talk about human rights, we also do human rights, and we work in partnership with public services and also with advocacy services. So we help kind of service deliverers put human rights right at the heart of what they're doing. We work with frontline doctors, nurses, social workers, local government officials to really think through human rights from their service delivery point of view. But we also work with advocates to help them use human rights in their advocacy to make sure that actually when people do fall through the nets or when public officials do overstep the mark, that human rights are there as the safety net to catch the people that they're supporting. And finally, we do a lot of work around protecting human rights, which is about ensuring those with power respect and protect our human rights systems and don't go backwards. And right now, there is a very big question mark about the future of the Human Rights Act. I will touch on that at the end of my presentation, but the key thing to remember is that the Human Rights Act is our piece of law here, and whether or not it's being discussed in terms of changing it or not, it still is the law. So we kind of have to use it because it's a really powerful tool at our disposal. So what I just want to do is talk through a little bit about human rights, where they come from, what they give for advocacy, what the value is, and then kind of talk through actually some of the ways that we've worked with advocates around human rights and kind of putting them into practice. So human rights are essentially based on shared values. Lots of the things that we talk about every day, things like dignity and respect and fairness and participation, the kind of, you see universal for all, the fact that they're for everyone there is a key value that underpins human rights, and I'll come back to that in a moment. So lots of these are the kinds of things that we use kind of probably much more frequently in our day-to-day language and our day-to-day advocacy. But human rights are a lot more than values. Values are the important flags that help us think, do I need to think about human rights here? Is this something where I need to go and say, what does the law actually say about this issue? How can it help with my advocacy? Because I was doing a session a couple of weeks ago with a mental health service user who said, gosh, I'd never thought that actually saying something is unfair is not a very practical way of looking at it. It doesn't really get me very far with my service. But if I say to them, I've got a right to be treated kind of in a way that makes sure my right to respect for private and family life is met, and you've got a duty to meet it, that's a fundamentally different conversation, which is all about empowering the person at the heart of decisions that are being made about them. So values are very important. They're the flags that make us kind of think, actually, is this a human rights issue? But values aren't human rights. They're the underpinning. Human rights gives us much more flesh, and it gives us much more to use in advocacy. So, as I say, they are more than values, and these are just some of the things that some of the people that we work with have told us about human rights and how they work for them. So Kath is a service user. She's a mental health service user in the northwest of England. And she talks about human rights as being the basic things to humane, dignified treatment, the things she should have access to just because she's a human being. Or Nikki, who works in a local authority as a manager, she talks about human rights as a set of recognisable principles on which authorities can base their everyday work. So not something fluffy, not something over here, but something that is about what they do day to day. And a committee in Parliament, the Joint Committee on Human Rights, which is kind of MPs and peers, they've done a lot of work looking at the Human Rights Act and what it means in practice. And they talk about the Human Rights Act as providing a legal framework for service providers to abide by and to empower service users to demand that they are treated with dignity. So kind of that whole idea that it isn't something that is conceptual, it's something that is practical and part of what we do on a day-to-day basis. And so what do human rights have to do with advocacy? Well, for my organisation, kind of everything, because essentially human rights provide a set of minimum standards that are backed up by legal duties for how public officials and services treat people. It is the very essence of what advocacy is, making sure that people get what they're entitled to, that they know what they're entitled to and that they're able to access it. And very often this idea of public officials or services, when we think of human rights, the term the state is used. And it's often this one here, the kind of lone protester at Tiananmen Square, standing up to the big tanks. But human rights are also about our day-to-day interactions, and they're just as much under the Human Rights Act, they're just as much the other image in terms of accessing an NHS service in a hospital. So they're these minimum standards, they're legal duties, they're not nice things to do, they're not added extras, they're not optional, they are the law, and they are about how public officials should be treating people. And the fact is that they do belong to everyone, and that's really challenging because it means that human rights belong to you irrespective of what you might have done, what you've been perceived to have done, whether you're a popular group, an unpopular group, whatever it might be. Kind of human rights aren't things that are supposed to be, they're not given to us, they're not a gift from the government, they're part of what it means to be a human being. That doesn't mean you have an absolute right to everything. Our rights can be restricted some of the time, provided a process is followed, and I'll look at that in a moment. And that's where it can be very practical. But the starting point is that they're for everyone, whether you're in a vulnerable situation or not, whether you're a popular person or not. And this is a quote which I'm sure many of you will be familiar with. It's from the Cheshire West judgment from last year. And it is from Baroness Hale, who is the Deputy President of the Supreme Court. And she said that human rights are premised on the inherent dignity of all human beings, whatever their frailty or flaws. It may be that those rights sometimes have to be limited or restricted, but the starting point should be the same for everyone. And that was about 3 people with various different disabilities, but you could put in anybody in that situation. Children, older people, adults, people with mental health problems, whatever it is. Anyone kind of can fit into that idea that we all have the same human rights. So you're probably already doing a lot of human rights. You might not be calling it human rights, but as I say, it is part of kind of what is at the heart of advocacy, because you're empowering people, you're enabling them to access services or resources, you are enabling them to participate in decision making, you're promoting the inclusion of marginalised people or people in vulnerable situations. So really the heart of advocacy is a lot of human rights work, but sometimes the missing link is the connection to human rights standards and the power that the legal duties and the practical framework that it can actually give us. So our law, as I said in the UK here around human rights, is the Human Rights Act. And it came in 1998 and it became law in October 2000, which is why my organisation has been on the road for 15 days straight, because we started on the 15th birthday of the Human Rights Act, the 2nd of October. And essentially the Human Rights Act works in 3 key ways, most of which are going to be relevant for advocacy. So the first one is that all other laws should be compatible with the human rights in the Human Rights Act. And that's quite a special way that the Human Rights Act works, because it means whatever other law that you're working with, it should be compatible with the rights in the Human Rights Act. So I apologise in advance because I'm not a visual learner, but this is my visual representation of how this works. I would always much rather read 10,000 words than try and put something into a picture, but this is my attempt. So the duty in the Human Rights Act, this kind of idea of compatibility, means that it's the foundation for all other laws. So a lot of our work, for example, our practice-based work is around mental capacity and mental health. So this is kind of some of the ways that we explain this to the services that we work with. So your Human Rights kind of Act is your foundation. You then have your next level up, which is the Mental Capacity Act, and then you might have other types of assessments, regulations, guidance, kind of that sit on top of that, for example, a best interests assessment. But whatever your kind of the piece of policy or law that you're working on, you should always be looking at it through the lens of the Human Rights Act, because it has to be applied in a way that respects human rights. And certainly in a lot of the work that we've done around the MCA and around DOLs, that's been one of the big issues, is that it's been divorced from the fact that those are human rights pieces of law. The fact that we have the MCA and the DOLs came out of challenges around human rights because there were protection gaps of people's right to liberty, their right to participate in decisions that were being made about them. But because they've sort of been separated, often what we're seeing in practice is the use of laws in ways that restrict rights rather than maximise them, which was the whole point of them. So we've seen lots of changes to laws in this way, and kind of this is the way that the Human Rights Act can be quite a powerful driver for change in getting laws right at the start or in the application of them. So as I said, kind of we've seen the development of the Mental Capacity Act, we've seen the development of the DOLs from this duty, we've seen a lot of changes to the Mental Health Act as well, in terms of making sure that it's compatible with people's most basic rights. Things like being able to have a say over who your nearest relative is if there's an issue around kind of abuse that might have happened in the past. Things like when you're at a mental health tribunal, the onus now being on the detaining authority and not the individual about whether they should or shouldn't continue to be detained. So lots of ways that we've seen how the Human Rights Act kind of has made sure that it's the foundation for other laws to make them compatible with people's rights. In practice, that just means whatever it is that you're looking at, apply it thinking about human rights, apply it in a way that is going to maximise people's human rights in that situation. The key one is the the public authority's duty. So essentially in Section 6 of the Human Rights Act, all public authorities have to act in a way that respects people's human rights that are set out in the Human Rights Act. And this is where all of my organisation's practice-based work with advocacy and with service providers comes from. This legal duty is the hook, because it can be a really powerful driver for practice in everyday experiences and services. Some of the examples from my work include a woman called Jenny who lives on the south coast, and she was a voluntary patient at a hospital. She has mental health issues, and she was essentially told by the staff, well, you can't leave. It wouldn't be good for you to leave. She's a voluntary patient. She can walk out the door at any moment that she wants to. But she was essentially being detained without any of the safeguards that would kick in with the Mental Health Act. So she did have an advocate, and her advocate talked to her about human rights. They're part of our advocacy programme that we run. And what happened then was we had a meeting, fairly informal, with the staff, with the ward manager, and just talked about Jenny's right to liberty, the fact that she wasn't detained formally. If there was a genuine concern, then perhaps she should be detained to make sure that she had access to all of the safeguards that were available. But that wasn't the issue here. And so having that discussion, talking to staff about rights and duties, essentially Jenny was able to go out. And all she wanted to do was to have a little bit of time off the ward, to go and get a cup of coffee, like probably everyone in this room has done this morning, and have a tiny little bit of time to herself. And it's a really small thing, but it made the world of difference to Jenny. And that's the power of using the language of human rights and the law, is that often it can be very small changes, but they're the changes that make the absolute difference for the person who you might be advocating for. And finally, any person now in the UK can ask a UK court or tribunal to look at whether their human rights have been risked or breached by a public authority. And there are many, many examples of this happening. It's UK courts, right up from the lowest court, right up to the highest court, to a local county court. It's the Court of Protection. It's tribunals, so it's mental health tribunals as well. All of these courts, all of these decision-making bodies should be thinking about human rights when they're doing their job, and now people have the ability to access them to ask if their human rights are being at risk. One example that comes to mind is one that was quite recent and involved a young boy who had gone to a swimming pool on a trip to see if it was somewhere that he wanted to go. He was with his carers, they were scoping it out. He has autism and epilepsy. He got very near to the front of the swimming pool and jumped in. Actually, that's not entirely true. He didn't quite jump in. The pool manager got concerned. The pool manager called the police. The police then turned up and went to touch him when the carers said it's fine, we can talk him down, there's no problem. He then reacted to that and jumped into the water. It then transpired with 5 police officers. He was pulled out of the water. He was put in handcuffs and leg cuffs, was left in a police van. So his family said, well, that's not appropriate, and they took the police to court, and the court said, yes, that is absolutely a breach of this young man's rights, his right to be free from inhumane and degrading treatment, his right to liberty, and a few other rights as well. So we now have that level of legal accountability if we need it. But as I say, the key thing is really that duty on public authorities, that idea that they have to respect and protect human rights in their day-to-day work, because that's really the hook for advocacy and everyday negotiation and discussion. And what the duty requires is essentially 3 things. Firstly, that public officials, through their staff, but public authorities, that they respect human rights. So that is the negative duty not to do something that impacts on people's human rights, so not to violate somebody's rights. The second thing is to protect human rights, and this is about taking preventative action, positive action, stepping in to prevent harm, often called the positive duty. And this is actually where safeguarding comes from. This is the legal underpinning for safeguarding. If you go all the way back to No Secrets, the first paragraph of it talks about the reason we safeguard people is in order to protect their most fundamental and basic human rights under the Human Rights Act. But I do an awful lot of safeguarding training, and my experience is certainly that the reason that we safeguard is to protect human rights is a link that has been fundamentally lost in a lot of safeguarding work. And then to fulfil, so the kind of have the processes and procedures in place to make sure people can enjoy their rights, but kind of more importantly, to make sure that there is a process when breaches of, or violations of rights do occur, the procedural duty. And this is where we see kind of the legal underpinning for reviews into things like abuse, neglect, and deaths that involve the kind of public officials or that are suspicious. So particularly at the moment, there's a lot around deaths in detention and looking at that issue. But in my past, I worked in the domestic violence sector, and a lot of the work I did with the police around domestic homicide reviews, this was the duty that I used to underpin that work. So in terms of the rights in the Human Rights Act, there are 16. It's fairly modest. They are fairly straightforward in terms of the things that they cover, things like the right to life. In terms of the ones that we see that come up the most often in the advocacy work that we do, it tends to be the right to life, the right to be free from torture, inhumane or degrading treatment, but not really the torture bit unless you're working specifically in a prison setting or a setting involving, say for example, sort of state kind of army services or kind of state sort of criminal justice services. It tends to be more inhumane and degrading treatment, the kind of really serious harm, abuse or neglect issues. Things like the right to liberty, and particularly the right to respect for private and family life, home and correspondence, because it's so broad, it covers so much of our day-to-day experiences. That's where we see things like the right to participate in decisions that are about us, the right to enjoy our privacy, the right to physical and mental well-being, the right to have relationships with other people, the right to have our respect for our home. So not to give us a home, but if we're in a care home, for example, respect for that care home, and not just taking that service away from us without involving us in that decision. So kind of lots of human rights have really really touch on our day-to-day experiences and the kinds of things that we're advocating for people. And as I said, the Human Rights Act is has both a principled and a practical approach, because most rights in the Human Rights Act are not absolute. There's a very small number of them where you cannot restrict that right for any reason. Freedom from inhumane and degrading treatment is one of them, but that's why it has to be very serious harm, abuse or neglect. So there's no justifiable reason for subjecting someone to that treatment. Most rights in the Human Rights Act can be restricted, but they can only be restricted if there is a law that allows them to be restricted, if there is a legitimate aim, and that is actually set out in the right itself. The right itself says the reasons for why you can restrict a right. Normally it's to protect that person or the wider public. And the key one is that it kind of has to be necessary in a democratic society as the legal terminology, but what that has developed into is this concept of proportionality. And we see that a lot, for example, in mental capacity legislation, in mental capacity guidance, this idea of the proportionate response. And again, that comes from the Human Rights Act and human rights. And this idea that we don't use a sledgehammer to crack a nut. And this is really where in advocacy we see the key practical, oh dear, that's a touch screen. This is where we see the key practical use of human rights. Because it's not kind of talking, it's not advocating with a public service and saying you can't do this, full stop, end of conversation. It's about saying there is a right here. We understand that you might need to restrict it for a good reason, but what you're doing is not proportionate. There are alternatives. Let's discuss a different way of kind of making sure this person's rights are met in this situation and that you've met your duties here. So it kind of is a very practical conversation and a very practical approach that you can have using the Human Rights Act as your kind of language and your base. So what I'll just do is I'll share a couple of really quick examples with you and kind of just flag up some of our tools and flowcharts that we've got for advocacy, and I will make sure that I kind of finish on time so that there's lots of time for questions. This is an example that we came across, and it involved a 51-year-old man with Down syndrome and dementia. And he had a do not resuscitate order placed on his file without him being consulted. And what is quoted on that slide is the exact reason for why he had a do not resuscitate order on his file. Down syndrome, unable to swallow, the dots just say peg fed, bed-bound learning difficulties. And it was indefinite in duration, said no one had been, family weren't available to be consulted, someone visited him almost every day. and the bit about whether he'd been given any information was entirely blank. This is not an unusual scenario. BIHR is in the process of training every single Care Quality Commission inspector on human rights and equalities and what to look for when they're out on inspection and in registration in terms of human rights. And I can tell you that I've delivered about 50 of those sessions, and at every session, do not resuscitate orders come up. And this idea that you cannot challenge because it is a clinical decision by a doctor. A doctor working in the NHS is a public official who has a duty under the Human Rights Act. Their decisions, yes, they have to be clinical, but they have to also be lawful, and that includes complying with the Human Rights Act. And you absolutely can challenge those decisions on the basis of human rights in your everyday advocacy. This man, it was actually a really interesting example because it was his care home that helped him challenge. He went back to his care home. It was the care manager that found the scrap of paper with the do not resuscitate on him. And they went back to the hospital and they advocated on his behalf. And they said this is about his right to life. This is about him not being discriminated against because he has Down syndrome. And the trust immediately didn't progress to a court case, settled, apologised. And we have lots of examples of that from our work. Some of the other examples are around cuts to services, where people have formed relationships with the people in the service that they have been receiving, and budget cuts have meant that the authority is saying, no, we're going to kind of find a cheaper way to deliver that service. The advocates who we work with are able to use human rights language to say that's going to impact their right to respect for private and family life, and actually it's going to cost you an awful lot more money later down the line when their mental health problems increase because you've taken away this support system from them. Or examples where we also work with services themselves, where we work with social workers, some of whom support families who are fleeing domestic violence, and the housing department in the same organisation, in the same service says, well, we can't provide any housing, we don't have any available. They're able to then say, well, there's a positive obligation to step in and protect people from inhumane and degrading treatment, and that's what's going to happen if you send this family back home to where they're fleeing from. And we have many examples of where suddenly safe accommodation is available when you use the language of human rights and the legal duties in the Human Rights Act. So just to kind of flag up some of our resources, this is taken from our mental health advocacy guide, which the CQC report, quite separately from when we were training them, the Mental Health Act report said every advocate should have a copy, and so should every detaining authority. We do have copies. If you want them, you can download all of our resources for free from our website, or just contact us and we can give you copies of them. And our mental health advocacy toolkit has 2 flowcharts in it. It has one which is about identifying a human rights issue, and it goes through how you identify a human rights issue and gives you lots of information about what is covered in each of the human rights, how it's relevant to mental health in particular. But because we're a charity and a lot of our work is grant funded, it's quite challenging to produce generic guides, because no one wants to fund something that everybody could use. It always has to be a new, exciting project that is very specific. But what we tend to do is design our resources in a way that means that they are accessible whether you're working on mental health or not. So all of the kind of information in this guide works whether you're working specifically on mental health advocacy or not. And again, this is one that was co-produced with advocates and service users themselves. So we have a flowchart in that which is about identifying human rights issues. We then also have one which is about identifying kind of how you use human rights in your advocacy, the various different steps that you would integrate it into your kind of the day-to-day work that you're doing. And that's a really kind of big message that I kind of want to hopefully leave you with, is that doing human rights work isn't doing something different. It's about strengthening the work that you're already doing as an advocate. It's not something extra. It is the legal underpinning for the work that you're already doing, and using it can really help kind of increase and amplify the power of the advocacy that you're doing. So please don't think of it as something that it's something extra that we do. It's about kind of part of your toolkit to make sure that you can advocate in the best way possible for people. So we see the Human Rights Act as being about empowerment. It's not something nice. It's the basics that every person should have. It's about challenge. It's advocating with and within power. And fundamentally, and probably the thing, I've been at BIHR for, I think, 8 or 9 years, And no matter who I'm working with, whether it's an advocate, a service provider, across any sector, the key thing that they tell me about human rights and the Human Rights Act and why it's useful is that it takes you away from an argument about who is most moral in this situation. It's not about what you think is right. It's not about what I think is right. It's also not a judgment on either person's character. It's about saying, this is the law, this is the standard, how do we meet it? And de-escalating what can often be a very confrontational situation. And as I say, also accountability. So when people do step over the mark, we have the ability to go to court. We have the ability to hold people to account for that. And I'm happy to pick up some of the questions, if people have questions about that, a little bit later on in the questions section. Some of our resources are kind of just up here. If you basically go to our website and go to what you need to know, there's a whole section on guides and fact sheets, and there's also a whole section called real life stories. Really simple stories of how people have used human rights in day-to-day advocacy to improve their situation. I did say I would just flag up that it is current government policy to scrap the Human Rights Act and to replace it with a British Bill of Rights. And the policy direction is essentially about setting out rights that the government wants to choose to give to people and the conditions for that. My organisation has a big problem with that because human rights are for everyone, they're not for some humans, and they're also not for governments of any political persuasion to decide what rights we do or don't have. So that's a big part of our policy and campaigning work. But what makes our policy and campaigning work really unique is that we tell stories like the ones that you are living every day. Is that I don't just talk to government ministers about kind of the philosophy of human rights, about where it comes from, about the rules that should be on them. I talk to them about stories like Jenny's story or VJ's story or Glory's story, the man with the DNR on his record. And I talk about how without the Human Rights Act, all of these people who are often at the most vulnerable moments of their lives would not have access to protection that would make sure that they get treated in the same way that any one of us would want to see. So it's really vital that we make the best use of the Human Rights Act and to share its impact in everyday life, because talking about how it helps and why it matters is a really big part of that conversation. And again, there are ways, if you are using the Human Rights Act in your work, for us to kind of share and amplify your story. So, just to leave you with a final couple of notes, this is my cheesy slide, which my staff at BIHR always try and ban me from using. But I really like it. It was drawn for us by a cartoonist for a piece we did in a paper around austerity and cuts and the Human Rights Act. And this is the key thing, really, is that whenever you're making any kind of decision, think of the Human Rights Act as the lens through which you look in order to make that decision. Because at the end of the day, what we should be doing is making sure that people's rights are respected in the best way possible. And so my final thought is that this quote from Eleanor Roosevelt, which again is becoming a little bit of an institution at BIHR. Obviously, I run a very collaborative approach to management, but it is almost required that you must love this quote in order to work at BIHR. And that's because, for me, it fundamentally captures everything that human rights are about and everything that advocacy is about. And it's from Eleanor Roosevelt, who was the woman involved in writing sort of the first sort of document that started the journey of human rights law, the kind of grandmother of our Human Rights Act, and it's called the Universal Declaration of Human Rights. And she said, "Where do universal human rights begin? In small places close to home, so close and so small that they can't be seen on any map of the world. Yet they are the map of the individual person, the neighbourhood he lives in, the school or college he attends, the factory, farm or office where she works. And such are the places where every man, woman and child seeks equal justice, equal opportunity and equal dignity without discrimination. And unless these rights have meaning there, they have little meaning anywhere. And without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world." And all too often in this country, we think of human rights as something that is over there and that isn't something for us. But actually, it is about all of the small places close to home for each and every one of us. And for the people that you work with and the people that you advocate with and for, human rights can mean the absolute world to them. And you have the most amazing job in making universal human rights mean something for people in their small places close to home. So thank you.